Good day, everyone, and welcome to the Foley and Lardner Environmental Law Update web conference series. Today's call is being recorded, and at this time, I'd like to turn the conference over to Ellie Kemeter. Please go ahead, please.
Thank you very much. Good morning, good afternoon, and welcome. I'm Ellie Kemeter with Foley and Lardner, and I'm pleased to welcome you to today's Environmental Law Update web conference. In this program, we address federal jurisdiction over wetlands and the proposed Clean Water Act rule, our EPA and the Army Corps navigating new waters. I'd like to take a moment to introduce our program speakers today. First, we have Tom Maurer. Tom is a partner with Foley and Lardner and the chair of the Environmental Regulation Practice. For over 30 years, Tom has represented clients in environmental and regulatory matters, including air pollution, hazardous waste management, underground storage tank, and groundwater contamination. Second, we have Sarah Slack. Sarah is a senior counsel with Foley and Lardner. She focuses her practice on remediation and redevelopment work, environmental compliance counseling, transactions, and environmental litigation. Lastly, we have Kathy Basic. Kathy is an associate with Foley and Lardner. She is a member of the firm's environmental regulation practice, along with the energy and sports industry teams. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. If you experience problems with Adobe Connect, please call 1-800-422-3623 for technology assistance. For audio assistance, dial star, then 0 on your telephone to reach the operator. Today's program has been set up in both a discussion and interactive question and answer format. We encourage you to submit written questions during the program. Type your question into the Q&A box at the right side of the presentation slides. We will respond to written questions at the end of the program, time permitting. To ensure you get the most out of today's presentation, we encourage all participants to maximize the PowerPoint to full screen usage. You can do so by clicking the full screen button located above the slides. The PowerPoint presentation will be available on our website at foley.com later this week, or simply click the Download Files button along the right side of your screen to get a copy of the slides today. As a reminder, today's program is being recorded and will also be available on Foley's website later this week. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Ellie Kemeter at ekemmetер@foley.com. To be eligible for CLE, you will need to log into the Adobe Connect session and answer a polling question during the program. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 4-digit code will be announced during this presentation. Please email the form to Ellie Kemeter at ekemmetер@foley.com immediately following the program. And now I'll turn the presentation over.
Thanks, Ellie. We're going to start with me giving you a brief introduction of the overview of the Clean Water Act and the history that brought us to this point. Then Sarah's going to talk about the case law, which is and difficult to navigate. And then Kathy's going to talk about agency interpretations in the proposed rule. And we'll take questions at the end if we have time, as Ellie explained. Really the oldest environmental regulation that we have at the federal level is Section 301 of the Clean Water Act and the 1899 Rivers and Harbors Act. Originally, the concerns were much more about navigation and being able to get up and down water bodies, but it switched over into more of an environmental and water quality concern as we move through our history. There's a prohibition on the discharge of any pollutant by any person except in compliance with the Act. Discharge of pollutant is to navigable waters, and we're going to talk about navigable waters throughout this presentation. In the wetland context, the Clean Water Act prohibits discharge of pollutants, dredged or fill material to navigable waters. Most commonly, especially at the federal level, that's placing fill in a wetland. Sometimes you hear referred to as dredge and fill. The second bullet here under examples, you can have regulatory implications on dredging, but it's due to the fallback or side casting from the dredging activity. It's really fill that is regulated. That's not the same. We're talking about federal regulations all day today. There are a number of states that actually regulate dredging as well as filling. Included is the clearing of wetlands, draining of wetlands, cutting wetland vegetation. And again, jurisdiction is only over navigable waters. And that's where the real rub comes as to what navigable waters and waters of the United States are. They include waters of the United States, including territorial seas, and it's regulated by both U.S. EPA and the Army Corps of Engineers, which have identical regulations. And I might point out that these regulations have been in effect with very little change for 25 years. So one of the reasons that there's controversy going forward with a regulatory change is that although there's been guidances over the years, the actual regulations haven't changed in a long time, and any time you make changes to a very established program like this, you're going to have controversy. Waters of the United States means all waters currently used or which were used for commerce. So if you could move a boat up and down a water body, it's waters of the United States. It also includes all interstate waters, including interstate wetlands. And then there's a whole lot of other waters that get included. Mud flats, sand flats, prairie potholes, pretty much any body of water that you could think of, which could be used by interstate or foreign travelers for recreational purposes, used for fishing, which could be used for industrial purposes by industries and interstate commerce. And it includes impoundments, so theoretically a bird bath could be included if the waters were from U.S. waters. Tributaries of the waters identified through 1 through 4 territorial oceans, and wetlands adjacent to waters that are otherwise regulated. So it can include a whole lot of water bodies. And exactly which water bodies are included is really the whole point of today's discussion. It doesn't include waters that were converted to effect. That is an EPA call as to when that applies. There's lots of reasons to care. If you're a developer and you're developing property, you're going to care about whether your wetlands are impacted and you need a permit for that. But there's a lot of other reasons you will be dealing with these regulations. There are permits prohibiting pollution. Drinking water supplies are implicated. Beneficial uses of water by property owners. And then we all care about the environment and the health of fish and other wildlife. And there's also a water quantity component with flood hazards that is taken into account. And there's been a tug of war for a long time over water or navigable waters and waters of the U.S. And with that, I'm going to turn it over to Sarah to get into some of the very difficult to navigate water case law about navigable waters. Sarah?
Thanks, Tom. So as Tom indicated in his discussion, the determination of whether a water or wetland falls under federal jurisdiction can have a significant effect on which statutory and regulatory regimes will apply to the use of that waterway or wetland. Oftentimes it's clear whether there's federal jurisdiction. Obviously, if water is navigable or if a wetland is adjacent to a navigable waterway, those are sometimes very clear determinations. But there's a lot of uncertainty on the fringes. And in light of that uncertainty, a number of the less certain jurisdictional determinations have ended up being decided by the courts. And because the court determinations have a direct impact on the current proposed rule, we felt it would be helpful to provide some background information. So the first case that we can kind of look to in the evolution of the development of the interpretation of waters of the United States by the courts is the case United States versus Riverside Bayview Homes. And that is a case in which that involved a developer who owned about 80 acres of low-lying marshy land near a navigable lake in Michigan. And the developer wanted to begin to fill the property to facilitate development back in the late 70s. And the federal and state agencies brought actions against the developer of the United States without proper permits. And this case got all the way up to the Supreme Court, where the court determined that federal jurisdiction over waters of the United States and wetlands extends to those waters and wetlands that are adjacent to navigable waters. So even though wetlands may be geographically and hydrologically isolated from waters, if they are adjacent to, they would fall within the jurisdiction of the federal agencies. So again, the rule that came out of this is that wetlands that are adjacent to traditional navigable waters are covered by the Clean Water Act, and that a wetland doesn't have to be navigable to be regulated. So again, this case came out in 1985, and as a result of this case, there was some uncertainty. The court kind of left open the question about isolated wetlands. They directly addressed the issue of adjacent wetlands, but because they left open the issue of isolated wetlands, the Corps promulgated a rule in 1986 that has been known as the Migratory Bird Rule. And basically, the Migratory Bird Rule was the Corps' effort to interpret to what extent it has jurisdiction over these non-adjacent wetlands. So their determination was that to the extent that an isolated water may be connected to other waters through use by migratory birds or by hunters and bird watchers who travel to see them, that was sufficient connection under the Commerce Clause for the Army Corps to assert jurisdiction over those isolated wetlands. So the Migratory Bird Rule was the rule for a long time, over a decade, until 2000, when another Supreme Court case changed that all around. And that case is the Solid Waste Agency of Northern Cook County, or SWANC, as it is commonly referred to. And SWANC is very factually dissimilar from the Bayview Riverside Homes case. In SWANC, the property owner owned a former sand and gravel mining site where there was basically a wetland that was both man-made and isolated. And the property owner wanted to fill that sand and gravel area that had been excavated as a landfill. But water had come and had developed kind of a pond there that migratory birds were visiting. And so under the jurisdiction of the Migratory Bird Rule, the Corps determined that it did have permitting authority and denied the permit on the basis that migratory birds are visiting it and that they had jurisdiction under the Commerce Clause. In SWANC, the Supreme Court soundly rejected the Migratory Bird Rule. The court focused a lot on the fact that they felt that the Corps was exceeding its authority in promulgating the Migratory Bird Rule. It didn't give a whole lot of guidance, though, with respect to what the actual constitutional extent is of the authority over isolated wetlands under the Commerce Clause. So the effect of SWANC was that it basically ended the Migratory Bird Rule and rolled back part of Bayview, basically demanding that there needed to be some sort of nexus or connection between navigable waters, above and beyond just the speculative Commerce Clause link from interstate birds. The SWANC court also noted that there should be more deference to states, which could more efficiently and effectively regulate these types of more isolated wetlands. And for federal jurisdiction to extend to isolated wetlands, the SWANC court again demanded that the wetland had to be adjacent to some sort of navigable water. So the SWANC decision again came down in 2000, and even as the ink was drying on that decision, the facts of the Rapanos case were developing. So the Rapanos case, the background of it, or the facts of it, are that Rapanos was a developer who owned a 175-acre plot in Michigan again, and wanted to clear the property and sell it for development. Now, the concern was that there were wetlands on the property that were connected via a 100-year-old man-made drain through two non-navigable tributaries to the Concurring River, which was navigable. Basically, the Rapanos property was about 11 to 20 miles from the nearest navigable, in fact, river. So the question was whether or not the federal government had jurisdiction over those wetlands. So again, for some more background, some interesting facts in this case, Rapanos' attorney contacted the state agency to discuss the issue, and the state agency advised that there were wetlands on the site. So as a result of that, Rapanos retained a consultant and identified up to 60 acres of wetlands on the property. This is where the facts take a turn away from what we would consider best practices. And Rapanos instructed their consultants to destroy the report and went ahead and started to clear and fill the wetlands regardless of the jurisdictional determination. So the state and federal agencies both brought actions based both on the migratory bird rule and on the adjacency of the wetlands. And they did obtain a judgment. But again, this was while SWANK was being developed, and after the decision, the court ultimately determined that there was no jurisdiction because the wetlands were not directly adjacent to navigable waters. Rapanos went up to the Sixth Circuit, which reversed, finding that that there could be a connection between the two, and that any contamination, in particular, that would affect the drain, could ultimately end up in the navigable waterway, even though it was 11 to 20 miles away. So again, simultaneously, there was another case that ended up being consolidated with Rapanos, and I just wanted to provide some information on that. That's the Caribou case, and in that case, again, similar facts. Caribou owned property that they wanted to fill, and it was approximately a mile away from an existing navigable waterway. And it was separated by a 4-foot wide berm from a man-made drainage ditch that then did flow directly to that navigable waterway. The Sixth Circuit in that case concluded that the wetland was connected to the tributary system one way or the other, and then basically upheld the core jurisdiction and denied the permit. So then in 2006, the Supreme Court consolidated these cases and addressed the issue of whether the Clean Water Act, whether there's jurisdiction under the Clean Water Act for wetlands that do not contain and are not adjacent to waters that are not navigable in fact. And the court ended up splitting here, 4-1-4. So there were 5 separate opinions, and there's no one majority. But based on this, the judgments in those cases were vacated, and the cases were remanded back for determination based on the court's rule. So with respect to the decisions, so the plurality opinion was written by Scalia and was joined by Robert, Thomas, and Alito. And again, this was a 4-party plurality opinion. And basically, the focus of Scalia's position was that in order for a wetland or a waterway to be navigable, it had to be relatively permanent. A quote is that at a bare minimum, wetlands require the ordinary presence of water. So based on this, the plurality opinion basically proposed a 2-part test. The first is with respect to the water body itself, and that is that the water body or the wetland has to be relatively permanent, have relatively permanent standing or flowing water connected to traditional interstate navigable waters. And then the second is with respect to the connectivity. And here, the Scalia test requires that there be a continuous surface connection to bodies that are waters of the United States in their own right. So basically, it has to be difficult to determine where the water ends and the wetland begins. Again, one of the focuses of the Scalia opinion was the need for the water or the wetland itself to be relatively permanent. And in the opinion, Scalia specifically said that would exclude intermittent and ephemeral streams, but that it did not necessarily exclude streams, rivers, or lakes that could dry out from time to time under extraordinary circumstances like drought, and that it did not necessarily exclude seasonal rivers that maybe have continuous flow during certain periods of the year, but that were dry during other portions of the year. So then the one in this case was Kennedy. He wrote a separate opinion concurring with the plurality, and in his opinion differs heavily to Swank. And he determined that the determinative factor for jurisdiction is whether there's a significant nexus between the wetland or water body in question and navigable waters. And he found that a nexus exists if the wetlands significantly affect the chemical, physical, and biological integrity of other covered waters more readily understood as navigable. And he basically said that the nexus needs to be determined on a case-by-case basis, depending on the wetland and the connection. And this test has generally been considered to be a more expansive interpretation of federal jurisdiction than would have been granted simply under the scope. And then there was a 4-party dissent in Rapanos as well. That was the dissent was prepared by Stevens, Souter, Ginsburg, and Breyer, and there they basically said that the courts should defer to the Corps. The Corps is the experts, and they should be able to determine what is a wetland and what it means to be adjacent. They referred back to Riverside, saying that to do otherwise would basically be to disregard that decision. And the dissent said that they would have affirmed the Corps' jurisdictional determination in both cases. So what happens post-Rapanos? Post-Rapanos, there are basically two rules that existed. One of them is the Kennedy significant nexus test, which is that a wetland will be considered will be considered waters of the United States if there is a significant nexus between the wetland and navigable waters in the traditional sense. And the second test is the Scalia plurality test, which is that a relatively permanent body is connected to traditional interstate navigable waters, and the wetland has a continuous surface connection with that water. But the issue that has remained and has continued to be a concern is which approach is the controlling test. 8 years after Rapanos is decided, the answer is still unclear, and there has been continued splits in the circuits with respect to which of the tests controls. This is a chart just to show a little bit some of the case law. This is not exhaustive by any means. It's meant to be just an example to show that there has been this continued split, and that in fact a number of courts have hedged by applying both tests. So there continues to be much uncertainty. So I'm also actually going to speak briefly about what the EPA and the Corps have done to try to interpret waters of the United States with guidance documents in light of some of these Supreme Court decisions. So Rapanos was in 2006, and then in 2008, the Army Corps and the EPA issued a joint guidance that was intended to provide additional regulatory certainty to the regulated community as to which wetlands and waters would be considered jurisdictional for purposes of federal regulations. And the guidance described jurisdiction based both on the Scalia and the Kennedy test. So in the guidance, the EPA and the Corps confirmed that they would assert jurisdiction over certain types of water, the first being the very traditional navigable waters that are generally not in question, as well as wetlands that are adjacent to those waters. It starts to get a little more gray, where in the guidance the EPA and Corps said that they would assert jurisdiction over non-navigable tributaries of the traditional navigable waters that are relatively permanent, again, looking back to the Scalia standard, and where the tributaries typically flow year-round or have continuous flow, at least seasonally. And they interpreted seasonally to be at least 3 months out of the year. And then they also said that they would include within the jurisdiction wetlands that directly abut such tributaries. The guidance also clarified that there would be certain circumstances where the Corps and EPA would evaluate on a case-by-case basis, applying the significant nexus test, whether certain types of waters would be considered jurisdictional. Those types of waters include non-navigable tributaries that are not relatively permanent, wetlands that are adjacent to non-navigable tributaries that are not relatively permanent, and then wetlands adjacent to but that do not directly abut a relatively permanent non-navigable tributary. So again, here the EPA and the Corps was harkening back to the Kennedy position, or the Kennedy test, and saying that there are circumstances in which there may be a significant enough nexus where these types of waters would be considered jurisdictional. The EPA and the Corps also took the guidance as an opportunity to clarify over which types of waters or wetlands they would not assert jurisdiction, which was again intended to help the regulated community. And here they concluded that they would not assert jurisdiction over swales or erosional features or ditches. The guidance also clarifies how the agencies anticipated applying the significant nexus standard. So the way that they articulated it was that they would assess the flow characteristics and functions of the tributary itself and the functions performed by all wetlands adjacent to the tributary to determine if they significantly affect the chemical, physical, and biological integrity of downstream navigable waters. And again, they also indicated that they would consider other factors, including hydrologic and ecological factors. So the 2008 guidance was in effect for a number of years, and then in 2011, the EPA and the Corps claimed that they were intending to further clarify which waters were jurisdictional under the Clean Water Act and issued draft guidance. EPA said that the previous guidance did not make full use of the authority provided by the Clean Water Act as interpreted by the Supreme Court, and both the EPA and the Corps claimed that the guidance would have increased jurisdiction, but it would have maintained jurisdiction in consistent with the jurisdiction provided under Smythe and Rapanos. Again, the agencies were seeking to improve predictability and consistency with how the jurisdictional determinations were being applied. The 2011 guidance was extremely controversial. A number of people felt that it basically was the agency's attempt to try to assert jurisdiction over every body of water in the United States. The agencies ended up receiving thousands of public comments, and they ended up actually withdrawing the proposed guidance in 2013, September of 2013. And now I'm going to turn it over to Kathy, who's going to talk about the Waters of the United States proposed rule that was recently issued. And with this transition, I'll just note that one of the things that's an interesting change here is that while the 2008 and 2011 versions of the guidance were guidance documents, EPA is now looking to actually amend the existing rule, which is something that both the regulated community and environmental groups have expressed interest in. Obviously, the contents of the rule is something that that is very controversial, but the fact that they're doing this in rule form versus guidance is something that is generally perceived to be good, particularly since Tom mentioned the prior version of the definition of waters of the United States is over 25 years old and has been very, very sparingly changed in those past 25 years. So, Kathy?
Yeah, thank you, Sarah. So we're getting to the meat of the big news nowadays. And like Sarah mentioned, that this is a proposed rule. It has not been enacted, so it's just the start of the rulemaking process. So on March 25th, the EPA and the Army Corps of Engineers proposed a rule, and it was published in the Federal Register on April 21st of this year. And similar to the agency's previous efforts in issuing guidance, the purpose of this rule, again, is to try to make things more clear for the regulated community, for state governments, for all the parties that are potentially impacted, and make the process less complicated and more efficient. Likewise, it seeks to increase transparency, predictability, as I mentioned, for all the interested parties. And according to the EPA, the rule does not change, or at least does not seek to change, existing exemptions and exclusions. And this is in particular reference to the agricultural and ranching sector. The public comment period is currently open and will remain open until July 21st. Depending on how things go, it might be extended, and as I will mention later, what we saw with the draft guidance in 2011, the public comment period was extended multiple times, so it would not be unheard of if the EPA extended the public comment period for this proposed rule, especially given the immediate response from all parties and all sides. So let's do a comparison between the current rule and the proposed rule. So here's what we have in the proposed rule. The proposed rule defines waters of the United States as the first four parts of this section 328, subpart A, 1 through 4, they're pretty much the same. So as you recall from the first slides that Tom was discussing, all waters currently used or susceptible to use in interstate commerce. And a common example is the Mississippi River. And then all interstate waters and all territorial seas and impoundments of these above waters. So this has pretty much remained the same in the proposed rule. No new hiccups here, and it's consistent with the guidance documents that Sarah discussed as well. This is where we see some changes. For number 5 of subpart A, we see that waters of the United States also include tributaries of waters identified in the above paragraph, so traditional navigable waters, interstate waters. And the interesting thing here is that while maybe the word tributaries is similar to the current rule, tributaries is now defined under the proposed rule. And the term tributary, the way it's defined is broader and suggests that newer waters would be under federal jurisdiction. So any water that meets the proposed definition of tributary would be considered a water of the United States. And this is true regardless. If the water is a perennial, intermittent, or ephemeral water. And related to the tributary definition, the water may flow directly or may flow indirectly to another water that eventually flows into a jurisdictional water. So that is one of the major changes for the proposed rule. And then another revision that we see is number 6, all waters, including wetlands, adjacent to waters identified in the above paragraph. So the way the current rule is written, it says wetlands adjacent to waters. However, as you see, the proposed rule revises this as all waters, including wetlands. So by revising this language and including all adjacent waters instead of only adjacent wetlands, the proposed rule is seeking to be more inclusive than the current rule. And these waters would be jurisdictional because they have a significant nexus to a traditional navigable water, interstate water, or the territorial seas. So the above 1 through 6 parts would be considered jurisdictional by rule. So if you meet one of those categories, the water is under federal jurisdiction. Now, Section 328A7 states is slightly different because it requires a case-by-case analysis. It states on a case-by-case specific basis, other waters, including wetlands, provided that those waters alone or in combination with other similarly situated waters, including wetlands, located in the same region, have a significant nexus to a traditional navigable water, interstate water, or the territorial seas. And this has been revised. The proposed rule omits a non-exclusive list of other waters that is included in the current rule. For example, the current rule currently lists other waters as lakes, rivers, mudflats, intermittent streams, prairie potholes. And so there's a list that's there. This proposed rule takes out that non-exclusive list. And also it deletes certain language where in the current rule, that an other water be one the use, degradation, or destruction of which could affect interstate commerce. This requirement is not in this proposed rule. So that is a big change too. And the proposed rule also, this section, says that other waters may be evaluated either individually or as a group of waters where they are determined to be similarly situated. So similarly situated, this language comes from the Rapinos decisions and the Supreme Court discussion there. But similarly situated is considered in the same region or within the same watershed. And as I mentioned before, this also requires a case-specific analysis to determine whether or not the waters or other waters meet the significant nexus standard. So some of the major highlights here is, one, currently the way that the EPA and the Corps approach federal jurisdictional determinations is, going out to the site, having a consultant perform a wetland delineation. The proposed rule encourages, however, the use of desktop information in making those determinations. So reviewing and analyzing watershed studies, existing USGS maps or state equivalent maps of wetlands or related waters of the United States, aerial photographs. So we do see a lot more encouragement in the proposed rule related to this secondary use of information or desktop review by consultants. And also, one of the big things that we see here in the proposed rule, and as I alluded to earlier, is that there are various ways that waters will be jurisdictional by rule. So pretty much we saw that a water would be jurisdictional by rule automatically if it's a traditional navigable water, an interstate water, a sea, and then we also saw if it's a tributary as defined by the rule. And what you will see here is that tributary is defined broadly. So as long as there's some evidence of flow to traditional navigable waters, and even if that flow is broken and associated with by road barriers or man-made structures, and if the ordinary high watermark or bed banks are present, the rule still classifies that the water has a significant nexus and therefore is a tributary. So some of those terms within the defined definition of tributary, ordinary high watermark, is also defined in the rule. Also, tributary includes natural and man-made waters such as canals and ditches, unless specifically excluded, and we'll talk about those exclusions in a little bit. Another important highlight of the proposed rule are some of its definitions. One of the major definitions that is included is the term adjacent. And adjacent the term currently is in the rule, but the proposed rule defines it and enlarges its application. Currently, adjacent is considered in the context of wetlands. However, the proposed rule changes adjacent wetlands to adjacent waters, so that waters like ponds and oxbow lakes, in addition to wetlands, can be jurisdictional by rule. So that, so in effect, the term adjacent has broadened the impact of the various categories. So adjacent waters are those that provide similar functions, which together with functions provided by tributaries to which they are adjacent have a significant nexus to traditional navigable waters. That's how it's proposed to be defined. There are other proposed definitions in the rule, in the proposed rule. This includes a significant nexus. There's no, besides the references to significant nexus in Supreme Court decisions and lower court decisions, it has not been defined to date. So currently, the proposed rule defines significant nexus as a water including wetlands, either alone or in combination with similarly situated waters in the region, and those that significantly affect the chemical, physical, or biological integrity of waters. And a lot of this language is borrowed from these previous Supreme Court decisions. And then finally, another high-level point to make is that the proposed rule directs the agencies to take an aggregate approach. In other words, to aggregate or consider
similarly situated waters, so waters within the same watershed or in the same region, such as tributaries, wetlands, and other waters that discharge to a traditional navigable water as meeting the significant nexus test. So this is especially important with regard to determining whether or not a water is adjacent to a traditional navigable water, as well as determining whether an other water, as described earlier, for whether an other water is considered a federal jurisdictional water. Now, the proposed rule also has certain exclusions of what is not considered a water of the United States. The current rule excludes wastewater treatment systems as well as prior converted croplands. This remains the same in the proposed rule. However, there's several new categories that are added or are proposed to be codified. While they are new or proposed amendments, these are long-standing policy categories that like the EPA and the Army Corps has already consistently chosen to exclude. So these are waters that have been already excluded under previous guidance documents, such as the 2008 and the draft guidance in 2011. These categories include ditches that are wholly excavated in uplands, drain-only uplands, and have less than perennial flow. Also excluded are ditches that do not contribute flow either directly or indirectly through another water to a traditional navigable water, interstate water, the territorial seas, or an impoundment of jurisdictional water. And certain features are also excluded. We have a list here: small ornamental lakes, water-filled depressions, groundwater. Again, these are long-standing policy these categories features have been excluded for a long time already by the EPA and the Army Corps, but now are just being proposed to be codified in the original rule.
So at this time, I'm going to read the CLE code for this program. If you're in need of CLE credit today, please enter this 4-digit code into the poll question on the screen after it's announced. The code is 8DW0. Again, that's the number 8, the letter D as in David, the letter W as in William, and the number 0. Again, if you are seeking CLE credit for the session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to answering the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the files pod to the right of the presentation slides.
Ellie, just let me know when I can continue.
So at this time, the poll is now closed, and I'm going to turn it back over to Kathy.
Thank you. In addition to certain exclusions that are proposed under the proposed Clean Water Act rule, the EPA has said that already existing exemptions under the Clean Water Act will remain intact, and some of these exemptions that have that are already in place include exemptions for agricultural stormwater discharges, certain return flows from irrigated agriculture, normal farming and ranching activities, upland soil and water conservation practices. And in addition, on the same day that the Army Corps and EPA issued its rule, it also issued an interpretive rule regarding the applicability of what normal farming means and how it applies under the Clean Water Act, Section 404 F1A. Pretty much the interpretive rule is essentially a guidance document, and it identifies 53 specific conservation practices that protect or improve water quality and would not be subject to Section 404 permitting requirements. And the agencies have indicated that the rule is effective, or the guidance is effective immediately, and that they would work together to implement the interpretive rule. Now, something that's very important about this proposed rule is that it relies on a connectivity study, or a science report called Connectivity of Streams and Wetlands, which was released on the same day, and it's included in the proposed rule as Appendix B. Now, what's interesting is that not only is the proposed rule obviously proposed, this science report is also proposed. It's in draft. And there's been a lot of criticism for the EPA and the Corps issuing a proposed rule based on a draft study. The EPA and the Army Corps has indicated that any final regulatory action on the rulemaking would be based on this a final version of the scientific assessment. Basically, the study is a review and synthesis of more than 1,000 pieces of relevant peer-reviewed scientific literature. And as I indicated earlier, it's a draft report, and so the EPA is currently accepting public comments and undergoing peer review on this connectivity study. So here are just some high-level conclusions that are made during in this connectivity study. One such conclusion concludes that streams, regardless of their size or frequency of flow, are connected to and have important effects on downstream waters. You could see how then why the proposed rule had broadened the definition of tributary based on a conclusion set forth in the study like this. It did also encourage, or it wants to allow agencies to determine on a case-by-case basis whether geographically isolated waters and certain other waters in the uplands have a significant nexus to the chemical and physical and biological integrity of downstream waters. So this proposed rule comes out of, a long history of guidance documents and, court decisions, and naturally and expectedly that it sparked a lot of debate and criticism, just like the draft 2011 guidance did. A lot of environmental groups support the rulemaking action. However, some believe that it should have gone a little bit farther in being broader and asserting jurisdiction over more waters. Nevertheless, the proposed rule does face a lot of opposition, especially from the agricultural community, ranching sector, and different development groups, the Housing Builders Association. Supporters of the rule argue that these critics and opponents of the rule are just using endless delay tactics to prevent the progress and the eventual codification of the rule. And they cite to the efforts made by opponents to the draft 2011 guidance, which ultimately was withdrawn. Other criticism that's been launched against the proposed rule is that it's stated that EPA and the Corps underestimated the costs and overstated the benefits of the draft rule of what would be the result. It also argued that the EPA is relying on incomplete data and flawed methodology. And further, that the EPA has underestimated the likely number of development projects that would be impacted. They use numbers that were from the post-2008 recession years, and therefore critics say that these are not representative numbers of the projects that should be expected in the future. And then other criticisms include that under the proposed rule, the greatest costs would be incurred by developers, mining companies, landowners, and other permit applicants. Congress has also been vocal in expressing opposition. On May 1st of this year, 231 representatives, including 19 Democrats, sent a letter to the EPA administrator expressing opposition and asking the Army Corps and EPA to withdraw the rule. They argued that, instead of clarifying the confusion, it actually creates more confusion, and that the proposed rule relies on undefined or vague concepts that would require the agency's quote-unquote best professional judgment and aggregation. And they also argue that the economic analysis is flawed. So every day we're seeing new comments being raised, new opposition expressed. Another example of opposition is from the Western Caucus for the Senate and Congressional Western Caucus. They argued that, one, they were upset that EPA did not consult with the governors of the western states. And then they also argued that the proposed rule specifies agricultural practices that are exempt from Section 404 permitting, but that the application of pesticides that may eventually end up in such waters are not excluded. Those practices are not excluded from the proposed rule and would impact agricultural parties. The EPA responded a week later to these criticisms, and one official stated that that nothing really changes. And in fact, whoever is required to get a NPDES permit, a discharge permit, would still be required, and whoever doesn't would not be required under the proposed rule. So looking ahead, the public comment period will end at July 21, 2014, but we do think it may be extended. EPA and the Army Corps would like to finalize the rule ideally by 2015. In the event that it is finalized, we can be almost certain that there will be challenges on the rule. And the practical impacts, we've already discussed that, various parties would be impacted, especially through the permitting requirements. Expanding the jurisdiction of the term waters of the United States, expanding jurisdiction over waters would have permitting implications on, Section 404, whether or not under Section 402, whether or not to get a discharge permit, under Section 311 of the Clean Water Act, whether a oil spill program SPCC report would be required. Further, according to the EPA, an additional 3% of U.S. waters would be subject to jurisdiction, and 17% of these waters would be other waters that are currently non-jurisdictional under the current regulation and guidance. And then EPA does cite the impacts to the ecosystem, and that there would be beneficial impacts to the environment and the ecosystem. With that, we would like to open up the presentation to any questions, and if we can provide answers to those questions.
So it looks like we do have a few questions. So first one is in relation to, I believe, Section 328A. Would other waters potentially include groundwaters connected to waters of the United States?
I think there, specifically, oh, go ahead.
I was going to say, yeah, there's a specific exclusion in the preamble that states that they would consider groundwater to be water of the United States.
Correct.
And then we did just get one other question, and I believe we did touch on this throughout the program, but maybe if we can just reiterate that definition. It says, how do they define adjacent? And that happens in the proposed rule, section 328.
Yep, I have that right here. So adjacent under the proposed rule is defined as bordering, contiguous, or neighboring. And the rule also has an example. It says waters including wetlands separated from other waters of the United States by man-made dikes or barriers, natural river berms, beach dunes, and the like are adjacent waters. In addition, because the term adjacent is defined as being those waters that are neighboring, they also include a definition of neighboring. The term neighboring, for purposes of the term adjacent, includes waters located within the riparian area or floodplain of a water identified in the above paragraph of this definition, or waters with a shallow subsurface hydrologic connection or confined surface hydrologic connection to such a jurisdictional water.
Great. So it looks like those were our only two questions. So I'm going to wrap up here. So the contact information on the screen is for all of the presenters today. So we invite you to contact any of them if you have additional questions or would like more information on their particular topics. And so that wraps up our Wednesday. And just as a reminder, the program is being recorded and will be available on Foley's website in the next few days. And then if you have any questions regarding CLE for this program, please contact Ellie Kemeter at ekemmeter@foley.com. And please take a minute or two to give us your feedback about the presentation today using the link on the screen. It is important for us to know your thoughts and helps us shape our programs going forward. Thank you very much for your participation.